doing Chapter 4 of the Real Smart Note, title registration. Number 1, common law regarding title registration. Void deed. Although it looks valid, it has no legal effect. Alright, you got that? Void means that it's not capable of transferring any title in the land from the vendor to the purchaser, so the transaction is completely null. Voidable is the option to void. That's what voidable means. Common law says a person can recover title upon proving in court that he or she was in fact the rightful owner and her title was transferred by a void deed. But you had to search through deeds to make sure the deed was true and not void or forged, and even then you weren't sure. 3 most common types of void deeds. Number 1, a forged deed. Number 2, a deed given in exchange for an illegal act or thing. 3, a deed signed in circumstances where the party can plead non est factum. Okay? Non est factum. That means that is not my deed. Non est factum. That's not my deed. You get that? This is where a person is unaware of what he's signing. He may have a person translate the contract he's signing, or he can't come back later and claim he didn't understand what he was signing unless he was misled and told wrong info. The Torrens system of land registration. This provides security in the holding of interests in real property, and it removes the need for looking back through the old title documents, the deeds. There are 4 important principles to the title registration system in BC. Number 1, indefeasible title. The title cannot be made void. Bullet 1, the indefeasible title guarantees the buyer that when he or she purchases a property from someone who is registered in the land titles office as the fee simple owner, they're protected by our land title system. As long as the buyer purchases the property in good faith, honestly, pays a fair market value, and then the buyer will receive indefeasible title. Bullet B, no one can dispute you are the registered owner. No one can take your title away. Bullet 3, if you purchased a home at fair market value from the person registered on title, you would have an indefeasible title to that property. Okay? And if it were later discovered that the registered name on the title was forged, what do? Well, you would still be the owner. The original or true owner could not get his property back from you. If he cannot sue the forger, then he may apply to the assurance fund. Page 23. All right. So 2, registration. So the title of the land or an interest in land does not pass until registered. The contract is enforceable between the vendor and the buyer, but does not take effect until registered. 3, abolition of notice. You do not have to search back through deeds anymore. 4, assurance principle. This compensates people who have lost the rights they would have had under common law. So, for example, they were swindled out of their property and they have no way of recovering it. They can apply to the assurance fund. To qualify. Number 1, the claimant has lost an interest or estate in land. 2, claimant cannot recover that interest or estate by court action. And 3, if the Land Title Act had not been passed, the claimant would have recovered the interest at common law by court action. So we got a chart here, page 24, the principle of indefeasibility. So, for example, land is not sold yet. We got Bob, the owner, forges a transfer to John, who registers the transfer. Now, how can an owner forge? I don't know. So John forges a transfer, but has not sold it yet. Oh, okay, so I get it. So Bob has not sold his property yet. He's the owner. John, he registers the transfer, forges the transfer, registers it, but he hasn't sold it yet. So the result, Bob can get his title back because John hadn't sold it. Assurance fund. So we got Bob, the owner. Then we got John, who forges a transfer and registers it. He sells it to Mary. Mary registered. Result, Mary she paid a fair market value. She dealt with the registered owner, and Bob cannot get his money back. All right. So John, here's another case. John, he forges a transfer and registered transfer of Bob's property. He gives it to Mary as a gift. Mary registers it. Or he sells it to Mary for $1. Or Mary was party to the fraud. So what happens? Bob can get the property back. Woo! Charges. The principle of indefeasibility does not apply to charges. What are charges? A mortgage is a charge on title, and therefore it's not protected under the principle of indefeasibility. So, for example, if John forges and transfers or registers a transfer of Bob's property, Carla registered a mortgage only for 50 grand. Result, Carla is not protected. Bob's title is free and clear as he is the fee simple owner because it was just a mortgage. Or we have John forges a mortgage of Bob's on Bob's house. He registers the mortgage only and then he sells the mortgage. Carla registers the mortgage only. Result, Bob can also get his property back, free and clear of mortgage, because the principle of indefeasibility will not protect Carla, and there's no assurance fund for her. A registered charge, a mortgage, is not given the same guarantee. Alrighty then. Holy shit, we've got so many things in this chapter. But where are all the... Let me see here. How come this chapter and the chapter we're talking about don't seem to match? Okay, anyway, just do what we can here. Alright. So we've got 25. Differences from the pure torrens. BC is not pure torrent system, meaning that BC did not adapt all aspects of the torrent system. There are some changes outlined below. Number 1, notations of trust. The adult, or the trustee, holds a title in her name in trust for the infant, the beneficiary in BC. We permit the notation of trust to be made on the title as long as the trust document is also filed at the Land Titles Office. 2, a form of documents. In BC, we must use the prescribed forms unless permitted by the register to do otherwise. 3, registered charges are not indefeasible. Charges registered on title are not given the same guarantee that they represent a claim against title. Registration process. We got 2 documents required. We got the transfer of an estate in fee simple, and we have the property purchase tax return. Items normally found on the certificate of title. The trust. In BC, a notation of the trust is made on the title, and the trust document is filed in the Land Titles Office. Let me just see in my book here. Do I have a what's the name of this? Oh, certificate of title. I just want to see if I have it here in my book. Certificate of title 4.11. Mm-hmm. 4.11. Well, anyways, I was just trying to find to see if I got the form here. We've got Form A, the Land Title Act Freehold Transfer Agreement to Assume. We got Mortgage. Yep. Alright, I can't really find it in here. Yeah. Well, Property Transfer Tax Return. Yeah, we got that on 1.6 and 1.7. Mm-hmm. Oh, there we got the contract to purchase and sale. So we got the multiple listing contract. Now we got the contract to purchase and sale. Is that what we're looking for? No, it's not what we're looking for, but whatever. Do everything step by step. Alrighty then. Alright, so we got, alright. So we got the duplicate of certificate of title. Register will only issue a duplicate certificate of title upon written request from the owner, and then only where the title is not subject to a registered mortgage or agreement for sale. Caveat is a note placed on a certificate of title by a person claiming an interest in that land that will hinder the sale of property. Bullet 1. It warns those looking at the title that a claim's been made. If a caveator, a person claiming an interest in that land, wishes to enforce that interest claim, they must start a court action within 2 months and register a certificate of pending litigation, a CPL, against the certificate of title. Bullet B, caveat is registered against the title to property listed for sale. So it remains on the register for 2 months and must be renewed or it lapses. And bullet C, if the caveat is wrongfully lodged against title, the caveator may be liable to pay compensation. A certificate of pending litigation, it will hinder the sale of property. This provides notice to anyone searching the title that court action has been commenced on this property. Builder's lien. A person or company has provided material or labor to improve the property. The Builder's Lien Act permits the filing of an affidavit called a claim of builder lien with 45 days. The homeowner must hold back 10% for 55 days, 7% for 55 days for condos. 26. Manufactured homes. Wow. Manufactured Home Act. It became effective in 1978. The purpose is to set up a method for central registration, similar to the Torrens system. Transfer. A manufactured home registry in Victoria is not the Land Titles Office. The register, once satisfied all documents are legally in order, then registers the interest claimed. Registration. These are the differences from the Torrens system of registration. Bullet 1, no certificate of title. Bullet 2, no indefeasibility. Bullet 3, no assurance fund. Bullet 4, in some cases registration is mandatory. Bullet 5, registry can take 2 to 4 days to process that registration. So decal number is for the lifetime of a home. That's what the decal number is for. No, if you fail to register, that has the same effect as under the Land Titles Act. The third parties are not affected by unregistered documents. All right, and we get a little star here. Mandatory registration as of April 1st, 1978. Number 1, home located on land that didn't belong to the owner. 2, home was or is owned by a dealer or manufacturer. All new homes would have to be registered. 3, home is to be sold. 4, home is subject to a security interest. And 5, home is to be moved. Security interest. To purchase a chattel, like a manufactured home, with insufficient funds, a person may want to use the chattel itself as security for the purchase price. There are 2 ways to do this. Bullet A, the seller transfers title on a manufactured home to the buyer. The buyer gives a chattel mortgage on the home in exchange for part of the purchase price. The buyer makes installments on the loan. Bullet B, the buyer purchases the manufactured home under a conditional sales agreement. And bullet C, the title remains with the seller until the buyer has made all the payments, after which title passes to the buyers. So it sounds like a normal mortgage, eh? The Personal Property Security Act, PPSA. Bullet 1. Both of these methods of financing are security interests under this act. Bullet B. As of October 1st, 1990, the Personal Property Act, the PPSA, there's another Personal Property Security Act, repealed the Chattel and Mortgage Act and the Sale of the Goods on Condition Act and the encumbrance security provisions of the Manufactured Home Act. So the PPSA provides a single form of registration, simpler and